Good day, everyone. My name is Russell John Baguinang. I'm here to tackle about the chord components. But first, what is the chord components? To you, and any idea what is chord components? The chord components is the comprised numerous chord structure. So diha, may bala nato kung unsa ang structure sa isa ka chord or unsa ang function sa chord ug unsa ang function sa chord and unsa ang unsay klase sa chord. So, let's proceed to the lesson 1, the historical development of the judiciary and the court. Lesson outcomes. At the end of the lesson, you will able to know the historical development of the judiciary, to know the creation of the court, and determine the classes of the jurisdiction. So, may I ask you a question. What is the different levels of the court? The different levels of the court is the Supreme Court, the High Court, and the District Court. So let's proceed to the constitutional history of the Supreme Court of the Philippines. The Supreme Court of the Philippines is progeny tribunal established in Act Number Philippine Commission on June 1, 1901. June 11, 1901, sorry. There is no unbiblical court joining the Supreme Court to the Real Audiencia de Manila set by Spaniard of the Audiencia Territorial de Manila. It is constituted by Major General Elwell Ortiz. This audiencia served as a background and the proper perspective of the detailing the history of the Supreme Court. The audiencia is a both exercise administrative and judicial function. So, it is the audiencia is the what a may I say the basis of what is the court nowadays. So let's proceed to the judicial system of the pre-Spanish Filipinos. The Spanish colonizer first arrived the Philippine archipelago. They found the indigenous Filipinos without any written laws. So dati kita mga Pilipino, we are not have any written laws implemented in our country. So these laws were believed in God-given, oral transmitted from the generation to generation. So dati they have a laws, but it's not a written but in oral. It is believed on what are fear in God or any religion, especially in the pre Spanish Filipinos. They believe on the Anito and Anita, or it is based on their traditions. The unit of the government is the barangay. So this barangay is adapt until now, but it is not what is this not it is a sorry, it is a more function to us also, especially in For example, karon ay there na nag-away datay sa Pupurok ana na nag-away. It is a the barangay is first in the Purok, and second, and di jud siya mahusay kay dito jud sa barangay. So diha dako ay siya kanang tabang ang barangay. So it is a judicial, especially na maghusay sa problema, especially in the naibikil ana. It exercise of his judicial authority by the dato acted the judge in the setting dispute deciding the cases of the barangay. So dati ang nagunit sa barangay is a dato. It is a judge or the hukom settings of the dispute cases of the barangay. So karon nagakuan karon kay sa chairman or the kapitan ang naga once ay hukom. So diha. So the government is the patriarchal and form unit of government. It was a barangay in the settlement about the 30 to 100 families, each barangay governed by the dato. The dato is exercise all the function of the government, the executive, the legislative, and the judicial. Until now, the executive in our quad and barangay is the captain. Barangay captain. It is the purpose in the barangay captain. And nowadays, let's proceed to the judicial system under the Spanish regime. During the early Spanish occupation, King Philip II established the Real Audiencia de Manila, which was given not only judicial but legislative, executive, advisory, and administrative function as well. This audiencia given a non-judicial role of colonial administration. When the Audiencia Territorial de Cebu, established in 1886, is the name of Real Audiencia Manila, was changed to Audiencia Territorial de Manila. It is composed the Governor General, and as a Presidente or the presiding officers, the four odores, equivalent associate justice, ancestor is the legal advisors in chief constable. There are both trial appellate court. The audiencia is the function like the allotment lands of seller and newly established of the pueblos. So let's proceed to the judicial system during the American occupation. The subsequent occupation by the Americans of the Philippines late 1890s. After defeat, the Spain and American War is proved the way the considerable changes and control disposition of government of the island. The judicial system established during the regime of the military government. It is the government function as instrument the executive and not of the judiciary, and independent and separate by the branch of the government. Secretary of the State John Hay on May 12, 1899, composed the plan of the colonial government of the Philippines would give Filipinos largest measure of the self-government and on May self-government. The plan is the completed the independence of the judicial manner by the judge chosen by qualified the local on and Americans. On the May 29, 1899, the General Etwell Stephen Ortiz is Ortiz, military governor of the Philippines, issued the General Order Number 20, established the Audiencia Territorial de Manila, is established the Territorial de Manila. It applies Spanish laws and jurisdiction and recognize the American military governor continue in force. So, let's proceed. The Audiencia proceeding by the officers, 8 members, organizer in the 2 division is the Sala de Civil or Civil branch of the Sala de Lo Criminal or the Criminal branch. It the General Ortiz himself who personally selected the first appointees of the Audiencia. Cayetano L. Arellano was appointed the president of the court. Manuel Aurulo as the president of the Sala de Lo Civil. Raimundo Melisa as the president of the Salo de Lo Criminal. Gregorio Areta and Lieutenant Colonel E.H. Crowder were appointed Associate Justice of the Civil Branch, while Ambricio Renzier, Julio Latente, Major R. Y. Young, and Captain Becamere were designated the Associate Justice of the Criminal Branch. So let's proceed to the establish of the Supreme Court of the Philippines. On June 11, 1901, Second Philippine Commission passed Act Number 136 entitled An Act Providing Organization in the Court in the Philippines is the creating of the court first instance justice of the peace court through the land. The judicial organization is an act concrete. The American lawyer and the Philippine Commission was patterned in its basic structure and similar organization by United States. The Supreme Court is under the act is composed the Chief Justice and the 6th judge. So the 5 members of the court is the quorum, and the coherence of the members is necessary pronouns of the judgment. The Anglo-American legal system under the Supreme Court of the Philippine Island is expected to operate the different from old Spanish system and the Filipinos were familiar with. The adjustment is had made to Heron's decision of the Supreme Court. During the years affected the blend of both Anglo-American and the Spanish system and preference was gentle transition of the old order to new. Let's proceed to the Supreme Court during the Commonwealth period. In 1935, Philippine Constitution is the plebiscite of the principle of the separation of powers. The the government, executive, legislative, and the judicial is the different articles thereof as the United States judicial power vested by the 1935 Constitution is the one that the Supreme Court is a such inferior court established by the law. It is developed the judiciary development determine the whether is the act established by the law is devoted the judiciary is determine whether the act of the department were harmony with the fundamental of the law, and the court is the Commonwealth composed a Chief Justice and 10 Associate Justice may sit a branch of the two division unless otherwise provided by the law. And let's proceed to the court of the Second Republic. After the Japanese occupation during the Second War, the subsequent independence from the United States Republic Act number 296 or the judiciary number of the 1948 was enacted. This group of together case over which is the Supreme Court exercise executive jurisdiction review on the appeals certiorari or the writ of error. Let's proceed to the Supreme Court under 1973 Constitution. The declaration of the martial law through proclamation number 1081 by former President Ferdinand E. Marcos in 1972 brought about the transition of the 1935 Constitution to the 1973 Constitution. It transforms had application of the court completion and function. This period brought the legal issues is the essential importance of the consequences. Among the were legality restriction of the new constitution and consumption totally by the government authority by President Marcos is the factual basis of the declaration of the martial law by the chief executive. The writ large of the during period of the relationship of the court and the executive who under amended number 6 to the 1973 Constitution had a assumed legislative power even while elected legislative body continue to function. In 1973 Constitution increased the number of the member of the Supreme Court to the 11 to 15 with the justice and the associate justice is 14. The justice of the court is appointed by President alone without the consent and approval and recommendation of any body of the official. So diha walay kana ang president lang ang nagapili unsay maglingkod sa sa Supreme Court without the provision of approval of the government official. Let's proceed to the Supreme Court under the revolutionary government. After assuming the office, the 7th President Republic of the Philippines after the successful People Power Revolution, the President Corazon Aquino declared the existence of the revolutionary government under the Proclamation number 1 dated by February 25, 1986. On the March 25, 1986, the President Corazon Aquino thought the Proclamation number 3 is the abolish the 1973 Constitution and put peace provisional freedom constitution. Under the article section, the Freedom Constitution provide provision in 1973 Constitution is the judicial were adopted in so far they're not consent with the Proclamation number 3. Output of the Constitutional Commission of the 1986 was submitted by the people. Ratification. The Filipino is ratified in the Constitution submitted them and the Constitutional Commission on the February 2, 1987. Let's proceed to the Supreme Court under the 1987 Constitution. In 1935 to the 1973 Constitution and to the 1987 Constitution provides the judicial power vested one government in such lower court may be established by the law. It is exercise of the judicial power in shared to the Supreme Court with the court below it. But it's only the Supreme Court the decision on what is the vested with the presidential value of the doctrinal authority. It is the interpretation of the Constitution, construction of the laws are the final beyond review the branch of the government. Unlike in 1935 to the 1973, however, the 1987 is the define the concept of the judicial power is include the duty of the court of the justice settle the controversies involving the rights and the legal, deniable, and the enforceable, but also is determine the whether have been grave abuse of the declaration of the lack exercise of the jurisdiction is the part of any branch the instrumentality of the government. This letter provision delictutes effectively the political question doctrines with a place specific question best submitted by political wisdom of the people beyond the review of the court. The 1987 Constitution provides for scientific safeguard ensure the independence of the judiciary. These are there are 11 safeguard of the judiciary. First is the grant of the judiciary is the fiscal autonomy, is the grant of the Chief Justice of the authority argument in any general appreciation judiciary. I wait. First, the the grant of the judiciary of the fiscal autonomy is the appropriation of the judiciary may reduce the literature below amount the appropriate previous years. Its approval the shall be automatically regarded release. The Grand Chief Justice Authority argument of any items general apportation of the laws of the judiciary is the form savings in items said appropriation of the authorized by the law. The removal of the Congress power to the deprive of the Supreme Court of its jurisdiction over the cases is the eliminate the section 5 of the article 8 is the grant of the court is the power appointment of all official in employment of the judiciary according to civil service. Article 8 section 5 6. The removal commission of appointment of the affirmation the appointment of the justice of the judge. Number 6 is the removal the Congress of the judicial power reduce the computation of the salaries of the justice and the justice during the concurrence office. The provision against the removal of the judge through the legislative reorganization providing the no law shall be passed reorganizing the judiciary when the undermine the security ensures of its member. It is a grant of the sole authority of the Supreme Court in order to temporary details of the judge. It is a grant of the sole authority to the Supreme Court no regulate rules procedure of the court. It is provision against the designating members of the judiciary any agencies perform the quasi-judicial or the administrative function. The grant administrative over the lower courts and its personnel, it is the Supreme Court. Yes, the Supreme Court is under the present Constitution composed of 14 associate justices. Is the member that appointed by the President least prepare the Judicial Bar Council at least the nominee every vacancy. Is the new process that depoliticize the Court of Justice ensure the choice of the competent judge and fixing the existing the vacancies without undue delay. So let's proceed to the classes of the jurisdiction. First is the general. The power of the court the adjudicate all controversy except those expectably withheld from the plenary power of the court. It is extend for the all controversies which is brought before the court within the legal bound of the right remedies. So diha si general. So siya ang nagahatag og kanang legal bounds or the right na unsa jud dapat buhaton para makuan ang kontrobersiya. Special or limited is the one of the strict of the court jurisdiction only to particular classes of the subject, such a limitation as may be provided by the law. It is confined the particular causes which is the can excise the under limitation of the circumstances prescribed by the court. Next is the original. Is the power of the court that takes judicial cognizance of the case instituted from judicial action. So it is the first time under the condition provided by the law. Next is the executive. Is the power of adjudicate the case proceeding of the illusion of all other court of that stage. Next is the appellate. The power authority find the superior of the court. They heard determine the cause but tried in lower court. Lower court is concise the superior court. It takes a case removed to it. By appeal, the writ inferior or decision of the lower court is a review by the superior court is the final judgment in order some lower court. So, bago siya muagi sa dako na court sa final judgment, muagi siya sa lower court. So, next is the territorial. The word itself, territory, it is the geographical area of the power can be exercised. So, it is the unsa iyang sakop na power na i-exercise. Congruent sometimes is referred to the congruent coordinate of the jurisdiction, which is the power confined upon different court, whether same different ranks of takes ordinance or the same stage of the cases in some different territories. Let's proceed to the lesson 2, the court, constitution, court, and the litigate court. The lesson outcomes. After the lesson, you determine only the court created by the Constitution and differentiate the jurisdiction of the Constitution Court and Legislative Court. There are two types of the federal court groups. Is the Constitutional Court and the Legislative Court. The Constitutional Court is the three-tiered system of the Federal District Court, the Court of Appeals, the ordinarily circuit courts, and the Supreme Court. The Article 3 is the Constitutional provides the creation of this court. Judge served for life. The legislative court is the various administrative court is the tribunal that Congress established. Created by the Congress need arise the power is established in Article 1 or the Constitution. Judge served is the fixed term. A Constitution Court is the specialized court with the jurisdiction over the constitutional matters and the legislative court is the court that created by the Congress under the implied power. So, ang kalaian nila kay ang Constitutional Court is the powered by the jurisdiction over the constitutional matters, and the legislative court by created by the Congress under the implied power. So, let's proceed. Introduction. There are only court created by the 1987 Constitution. This court has a power settled actual controversies involve the rights which are the legal, deniable, and enforceable. It is the uh, Supreme Court. Um, the Supreme Court is defined as the right determine actual controversies arise by adverse litigants duly instituted by the court in a proper jurisdiction. It is the authority to settlement justiciable controversies or dispute involving rights that enforceable deniable before the court of justice. It the redress of the wrong for violation such a rights. There are there are there are a value. It is defined as a unit of place where jurisdiction can be exercised. Um, it is a court, yes, and jurisdiction. It is defined as a power of the court heard and tried any cases. So, kabalo. Next is the distinguish of the preliminary investigation to the preliminary examination. In order to the court of jurisdiction over the case and the following requisite must be satisfied. So, first of all, what is the preliminary investigation and the primary examination? To you, what is the preliminary investigation to the and preliminary examination? The preliminary investigation is the inquiry of proceedings and determine whether sufficient ground engender well-founded belief that crime have been committed and the respondents probably guilt therefore thereof should be held by a trials. The primary examination naman is merely essential step determine whether the investigation is necessary. It is detected by the particular individuals nor executed by the section against the state being subject of the examination. Jurisdiction over the case. It is the execute the court and have a jurisdiction over the case matter. It is the municipal court, the municipal trial court, the municipal circuit trial court, circuit cities shall be jurisdiction have over cases penalty 6 years and below. The case is the with more 6 years under the sala of regional trial court judge. Next is the jurisdiction over the territory. The court satisfied by the jurisdiction over the territory is the latter will be requisite the crime which was committed by the territorial jurisdiction of the court. Next is the jurisdiction over the person of accused. The last requisite is the jurisdiction over the person of the accused. These are referred to the power to the court over accused. The court will gain jurisdiction through the following circumstances. It arrests whether without warrant or with warrant, and voluntary surrender by accused. Um, uh, the jurisdiction of the regular courts in criminal cases. Let's proceed to the Supreme Court. Supreme Court is the 1987, according to the 1987 Constitution, Article 8, Section 5, the Supreme Court exercises the following powers. First, exercise jurisdiction over the cases affecting the ambassador and other public ministries and consul and other petition of the censurary prohibition, mandamus, quae warranto, and habeas corpus. It is a review, revise, reverse, modified, or affirm the appeals of the censurary as the law of the rules of the court. It is the provide the final judgment and order lowers in court in all the cases is the constitutionally validity of the treaty and international executive agreement of the law, presidential decree, and proclamation or order, instruction, ordinance, and regulation, as in all the cases involve the legality and any tax imposed, assessment, or toils, and any penalty imposed the relations, and all cases that jurisdiction in any lower court in issues, and all criminal cases which is have a penalty imposed and resolution perpetua or high or higher. All cases is error, a question of the law involvement. Third is assign temporary judge in the lower court and other station as a public interest may require. It is such temporary agreements shall exceed by 6 months without consent is the judge concerned. Other change value of place trial avoid miscarriage of the justice. Promulgate the rules concerning the proclamation and enforcement of the constitutional rights preceding practices procedure in all courts. It is the admission that practice the law is integrate bar and legal assistance in the underprivileged. It's such a rule provide a simplified, inexpensive procedure. It is a speedy disposition of the cases. It shall inform the all of court is the same grade and it shall not have diminished increase of modified submissive right. The rule of the procedure in the special court and quasi-judicial bodies shall remain the effective unless disapproval of the Supreme Court. Appointment of the official and employee in the judiciary is the accordance of the civil service law rather. The Supreme Court adopted the promulgate the rules of the court for the protection of the enforcement and constitution and high proceedings and practices and procedure in all court. It is admission that practice of the laws and amended the promulgate through the committee and revision of the rules of the court issued the administrative rule regulation from the court insurance according to the Supreme Court e-library website. Only take note that the one of the court created by the Philippine Constitution is the Supreme Court. The rest is the regular court such a court of appeals, regional trial court, municipal trial court, and municipal trial court in cities and metropolitan trial courts was created by the legislature. And let's proceed to the Judiciary Act of 1948 RA 296 as amended by the BP 129. Section 17. Jurisdiction of the Supreme Court. The Supreme Court shall have original jurisdiction and over cases affected by the ambassadors, public ministers, and consul. Is the original executive jurisdiction in petition for the insurance of writs of certiorari prohibition and mandamus against the Court of Appeals. Court of Appeals. The Republic Act No. 7902, an act expanding by the jurisdiction by Court of Appeals amending the purpose of Section 9 of BP 129 as a amended. Section 1. Section 9 of Batas Pambansa Block 129 as amended known as Judiciary. Reorganization of Act 1980 hereby further amended by the read as to follow. It is the petition insurance that prohibition of mandamus, quaranto, or habeas corpus. It is a action of the Roman Catholic Church is the municipality towns of the Filipinos Independent Church is controversy in the title ownership and administration purpose, the hospital, event, and cemeteries and other use of connection within in action brought a government of the Philippines is against in Roman Catholic or vice versa for no title ownership or hospital, asylum, and charitable institution is a kind of property. In the action of the prevent restraint violation of the law is the concerning the monopolies combination of the restraint trade. Let's proceed to the regional trial court. The regional trial court by the virtue of BBP 129 and an act reorganizing the judiciary, appointing the fund, therefore their purpose to jurisdiction of RTC and prescribed below Section 20 jurisdiction in criminal cases. Regional trial courts shall be exercise the executive original jurisdiction in all criminal cases which is not within the executive jurisdiction of any court and tribunal bodies except those now falling under the executive current of jurisdiction of the Sandigan Bayan, which is a shall hereafter executive taken by cognized by the latter. Municipal Trial Court. Under the same law, BP is amended the criminal jurisdiction of the Municipal Trial Court, Metropolitan Trial Court, and the Municipal Circuit Trial Court. It is a let's proceed to the section 32, jurisdiction of Metropolitan Trial Court, Municipal Trial Court, and the circuit trial cases. Except these cases is a falling within the executive originally jurisdiction in the regional trial court is the Sandigan Bayan. The Metropolitan Trial Court and Municipal Trial Court exercise is the executive regional jurisdiction and over violation or the city municipal ordinance commit their respective territorial jurisdiction. Executive original jurisdiction is over offenses punishable within imprisonment is none exceeding 6 years, integrative amount of fine regarding the impossible and accessory of the penalties. Let's proceed to the Rule 40, Rule of the Court. Appeal of the Municipal Trial Court in the Regional Trial Court. Section 1. Where is appeal? An appeal is the judgment in the final order of the Municipal Trial Court is be taken by the Regional Trial Court exercising the jurisdiction over the area and former pertains. The title if the cases is remain within the court origin of the part, but the party appealing of the case shall further refer to the applicant or the advisors of the party as be appealed. Section 2. When to appeal? An appeal may be taken by 15 days after the appellant of judgment or final order appealed from where the record appeal required. The appellant shall be filed notice of appeal, and the record on appeal is the 30 days of notice of judgment of the final order. The period of appeal shall be interrupted by timely motion of the new trial of the reconsideration and no motion of extension of time file motion for new trial recommendation shall be allowed. Next is how to appeal. An appeal be taken failing by notice appeal by the court render the judgment of the final order is noticed by the appeal shall indicate the parties to the appeal. The judgment or the final order part is whether appeal from the state of the material dates showing the timeline of the appeal. The record of appeal shall be required in only special proceedings. In other cases, in multiple separate appeals. The form of contents of the record shall be provided in the Section 6, Rule 41, and copies notice in the appeal of the record of appeal is required shall be served on advice of the party. Rule 42. Petition for the review from the Regional Trial Court and the Court of Appeals. Section 1. How to appeal taking from failing. A party desiring of the appeal from decision of the Regional Trial Court rendered in exercise is appellate jurisdiction may file verified of the petition is reviewed with a Court of Appeals, paying of the clerk said to the responding docket with other loss fees depositing by 500 for costs and the furnishing of the Regional Trial Court advice party with a copy of the petition. The petition shall be filed in the served within 15 days from the notice decision through the review of the dental petitioner's motions and new trial a reconsideration filed due after the judgments. Action of the petition. The Court of Appeal may acquire the respondents of the file a comment of the petition, not only the motion to dismiss within 10 days from notice of dismiss of the petition, it will find the same the patently without merits or prosecuted by manifestly for delay, if a question rise within the unsubstantial required consideration. Section 8. Perfection of appeals. Effect thereof. Upon timely failing petition review, payment corresponding docket with the law on fees. The appeal and deemed reflected the petitioners. Next is the Rule 45 is the appeal by certiorari of the Supreme Court. Section 1 is the failing petition of the Supreme Court. A party desiring the appeal of certiorari of the judgment of the final order resolution of appeals. The Sandigang Bayan is the regional trial court is the court whether authorized by the law may file the Supreme Court verified the petition review of the certiorari. The petition shall be rise of the question of the law which must be distinctly set forth. Section 2. The time failing extension is the petition shall be filed by within 15 days notice by the judgment of the final order resolution of appeal from the denial petitioner's motion The new trial court reconsideration the filed in the due time after the judgment. On motion, duly filed and served with full of payment with doc, will law fees and deposits of the costs. Before expiration of the regulatory period, the Supreme Court may justify justice, justify justify the reasons grant the extension of the 30 days of file petition. Section 6. Review discretionary. The review of not matters the right but the Sal's judicial discretion will be granted and only their special importance reasons thereof following while neither controlling the measures of the court discretion and indicate by the character of the reasons will be considered. When the court a quo decide the question substance not therefore determine the Supreme Court is decide the way probably the accord with the law with an acceptable decision by the Supreme Court. When the court far department accept the usual course, the judicial proceedings is sanctions such a departure or the lower court as called the exercise of the powers supervision. And that's all. Thank you for given time to listen my discussion.